Thank you, and thank you for having me out. Briefly, for those of you who aren't familiar with Pacific Legal Foundation, we're the nation's oldest conservative, libertarian, nonprofit legal foundations. We were founded in 1973 after a group of conservative thinkers looked and saw just how much impact the liberal civil rights organizations were having, particularly with the state and federal Supreme Courts. They said, we need to have a voice in this because these organizations were helping to shape the law, both in the moment and going toward the future. So Pacific Legal Foundation was formed in California. It was the brainchild of people who worked with Ronald Reagan, so they were advancing the early libertarian principles based primarily on property rights, although we also represent clients in a variety of issues, all based on libertarian conservative philosophy. The Constitution guarantees three fundamental rights, and most of the rights that we enjoy fall under these three: life, liberty, and property. Well, it's easy to define life and liberty, but property, when we're talking about property rights, often we're at a loss because property means so much. Just earlier today, somebody was talking to me, property is about more than just land. It's about money. It's about your future. It's a legacy. It involves almost every aspect of your life if you own property. Well, tonight I want to talk about what is this, the property. We often call it one of the cornerstones of liberty, because so much flows from property ownership when you own property, and so much is lost when it's taken from you. So I'll talk about what is property, why should we care, and how do we protect it. So first, the term property, just from a legal sense, refers to a collection of protected rights inhering in an individual's relationship with his land or chattels. So it's not just property being the right, but it's all of the things that you can do with it, all the things that it can do for you. Often scholars talk about a bundle of sticks as being property, with each stick being something like your right to sell, your right to rent it, your right to build on it, your right to do nothing but keep other people off of it. Each one of those sticks is inherent in property ownership. Different types of property have different rights. Shoreline property owners, and this is very important because shoreline property owners are sort of getting the brunt of regulatory reform with critical area ordinances and shoreline regulations just eating away at this bundle of sticks and taking away stick after stick after stick until you're stuck holding just one. But ever since the founding of Washington State in particular, our courts recognize that shoreline property owners have heightened rights because of the location near property. They include the right to protect your property from erosion. Yeah, I heard that. There's almost every critical area regulation, shoreline regulation, says you don't have that right. Well, you do. The right to access the beach, and the right to engage in customary aquatic pursuits such as boating, fishing, and swimming. All of these rights are under attack right now to one degree or another. And getting back to some of my initial comments, what is property? We could probably brainstorm and come up with dozens of examples of what the worth of property is. But these are some of the most basic. It's your home, for one. So you have to be sovereign on your property. It has to be inviolable. Government cannot go into your walls without a warrant. It's security. Those walls, the fence, it's your perimeter. It's where you are safe against the world. It's prosperity. Your property is probably your best investment. For most people, it's their largest investment, especially in Washington, where it costs a heck of a lot to get in. Your right to develop, your right to sell, your right to subdivide, all of those aspects of your property relate to its its financial well-being. And finally, privacy. I'm going to talk about this in a bit, but privacy is an essential component of property, and it's one of the aspects of property that's under the most attack by current government regulation. Now, to start tonight's discussion, I want to quote from probably one of my favorite U.S. Supreme Court decisions, one of my favorite treatments of property as a right. This is from the case Lynch v. Household Financial Corporation. The dichotomy between personal liberties and property rights is a false one. Property does not have rights. People have rights. The right to enjoy property without unlawful deprivation, no less than the right to speak or the right to travel, is in truth a personal right. In fact, a fundamental interdependence exists between personal right to liberty and the personal right in property. Neither could have meaning without the other. And that's why we're all here today. Everybody here understands that that's a fundamental truth. So, how do we protect this right? Well, we have the 5th and 14th Amendments to the Constitution that say that no person shall be deprived of life, liberty, or property without due process of law, and no property shall be taken for public use without just compensation. Washington has a similar provision in its Constitution. It says private property shall not be taken for private use. No private property shall be taken or damaged for public or private use without just compensation having first been made or paid into the court. Blah, 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 blah. If only those words were the law. Sadly, since they were written, government has figured out ways of getting around it, ways of avoiding the obligation to pay just compensation. Eminent domain is a terrible power. It's probably one of the most terrible powers that government has, besides taking somebody's life, is the exercise of eminent domain. That is the power to go in and take you out of your home and say, this isn't your home anymore. This isn't your land anymore because we want it. We think we can do something better with what you have, so we're going to take it. That in our system of government is unlawful unless they are willing to pay you for it, to make you whole. Well, over the years, this idea of, really early on, the government figured out that it could avoid outright taking property by regulating it, by putting restrictions on it so that it loses its value to you. You lose your ability to develop on the property or use it as a farm or whatever it is that your intended purposes were. For a long time, the courts were saying that that's not the same thing as us marching troops onto your property or running a highway through, because we don't see a highway. We don't see people on there. Therefore, it wasn't taken. It's just less useful. Well, the courts saw through that. Although they haven't always been clear, which is probably one of the biggest problems we have in the property rights movement, is that the courts have been anything but clear in what constitutes what we call as a regulatory taking. One of the earliest cases to discuss this says that government will have to pay you for your value of property when the regulations go too far. That was the touchstone of regulatory taking for decades. That tells us nothing. What is too far? If they take half your land, what's the remedy? But recognizing that regulation can take private property was a big step. In Pennsylvania, Cole v. Mahan, Supreme Court wrote, "We are in danger of forgetting that a strong public desire to improve the public condition is not enough to warrant achieving the desire by a shorter cut than the constitutional way of paying for the change." That quote could not be more relevant today, where we're being told that you can't use your property or that you're going to have to dedicate massive chunks of your shoreline property as no-touch buffers to serve the public good because the public needs it. That is no excuse for shortcutting the constitutional requirement to pay just compensation. So how can, one of the top topics that we always deal with in this environment is critical area regulations, because those are the regulations that, if you're lucky enough to have your property declared critical or adjacent to critical, or however they want to designate it, you understand just how strict the regulations are, just how draconian those measures can be. In King County, one of my early cases was challenging King County's critical areas ordinance, where they decided that the streams that were reaching the Puget Sound were severely degraded. In order to improve the health of the streams, they weren't putting restrictions on urban areas. I mean, we all know that the streams run from the Cascades down through the rural to the suburban, into the urban, and then into Puget Sound. So nothing you can do upstream is going to help the fact that it's running through Seattle or through Kent eventually. But wisdom aside, the city of Seattle decided to take all rural properties and say, cut them in half. You can only use one half of your property. So you purchased a 10-acre farm, you want to build a house on it, you have to take, well, more than half, 65% of it, and say this part of my property can never be touched to protect stream health. Now, we had problems with their scientific conclusions that was even necessary to protect stream health, or that it would have any impact on stream health. But at its core, we challenged that regulation as going too far, and we won, and we got it stricken. That was a high point in the property rights movement, taking on King County and having their, really one of their hallmark measures in their critical areas ordinance thrown out by the courts. So how do they, that one was obvious because it said you just take 65% of your land and you set it aside forever. But how do other critical area regulations affect property rights? Well, the most immediate is you get big setbacks or buffers. You get instructions as to how you can use those buffers. Replant them with native vegetation, get rid of your shoreline view, all sorts of restrictions on it, whether you can use it, whether you can let your animals even cross it. Development restrictions and use prohibitions on your property. Increased permit costs. I'm sure you would attest that if that building permit included property with a critical area, those 3 hours were probably turning into many more than that. The possibility of civil and even criminal penalties if you use your property in a way that the government does not want you to. Your home can be deemed a non-conforming structure, or existing uses can be deemed non-conforming, which says that over time they have to go. And this last one is something that I've been very focused on lately. If your property contains a critical area and you get a permit to build a deck, to do anything on your property, not even related to the critical area, the codes in our community, Bainbridge Island, Kitsap both have it, say that by accepting the permit, you have consented to warrantless searches of your property to see if you were in compliance with critical area policies, even beyond the developments that you got a permit approval for.
Incredible.
Yes. So almost all of the rights that we just discussed in hearing in property are at risk if your property is deemed critical. So we often hear, one of the most frustrating things about being a property rights lawyer doing this exact argument, taking critical area policies to courts, is every single time I take the government to court on a critical area buffer, they act like they've never heard of such an absurd thing as a buffer taking property. All they're doing is requiring you to use your property in a way that's beneficial, blah, blah, blah. You get all that. What they fail to realize is one of the most important U.S. Supreme Court cases on takings, on regulatory takings, was exactly that. It was about a shoreline buffer. So, the state, South Carolina adopted something that was much like our Shoreline Management Act. It was called the Coastal Zone Management Act, that required every local government to adopt regulations designed to protect their shoreline environment. Sound familiar? So the agency that was promulgating these regulations put together a body of best available science that says that in order to protect the dune environment, this is, dunes, the tide's very far out there, you need to impose no-build buffers. So here we have a couple of pictures. I'll explain them. Above is the lots. In this case, it's called Lucas v. South Carolina Coastal Council. The two arrows are two vacant lots that Lucas purchased. That's the development. It's in a neighborhood. You can see another angle of it right there with the two gaps in the development. It was a community that was built out. It was a zone for residential use. He purchased the property, had the expectation that he would build two homes there, live in one, probably sell the other one. Well, anyway, the Coastal Council decided to increase the environmental setback, a buffer, to protect the coastal ecology. Those buffers were supported by best available science. We hear this argument all the time too, that don't complain because our buffers are supported by science. Our science says that we need your land. That does not get you past the just compensation requirement, because the just compensation requirement in the Constitution doesn't say thou shalt not unless you have science. It says thou shalt not unless you pay. Anyway, back to Lucas. This next slide shows, this is a diagram of those homes you just saw, with number 11 and 13 being Lucas's lots. The yellow line is the old setback line up to the beach. The buffer regulations moved it to the other side of the house in the middle of the street behind them, effectively making those lots undevelopable. Well, Lucas took the case to the South Carolina Supreme Court and lost. They said, heck, exactly the exact argument that we hear all the time, which is why it always flabbergasts me when I hear now, almost 30 years later, government attorneys making the exact same argument and advancing that argument. The South Carolina Supreme Court said, sure, we can regulate you, we can take away your property because it's for the good of the public. Well, they took that up to the U.S. Supreme Court, and the U.S. Supreme Court adopted what's called the total taking doctrine. That is one of the per se regulatory takings doctrines, that you don't need to go beyond, you don't need to prove that the government intended to do anything or the character of the government action when its regulations are imposed in a manner that deprives you of your interest in the property, of your right to make some economically viable use, which is what those homes were. Justice Scalia wrote that the setback requiring land to be left in its natural state presses private property into public service under the guise of mitigating environmental harm. It was the equivalent of creating a wildlife preserve and destroyed all economically viable use of the land. So, we question ourselves, we are back in this, addressing this Lucas argument. Capo is addressing this in all the shoreline updates and critical area updates. But one of the things that sort of escapes most regulators' view is they go all in on these regulatory updates. They act as if it's the most important matter in front of them to expand buffers or eliminate uses. Well, let's go to the epilogue of Lucas. So Lucas goes to the U.S. Supreme Court. He wins. It goes back to South Carolina. Just compensation clause says, you exercise eminent domain, you have to pay. So the South Carolina is forced to pay Lucas for those two homes, or those two sites. So what happens? This policy, of protecting the coastal environment that was so important that they took it to the U.S. Supreme Court and had to pay, that's Lucas's lots. The government sold it to private developers shortly after they purchased it, and now they're homes. It's ironic, it's sad, but it goes to show that these policies are not necessarily right just because we're told that they're right, just because we're told that they protect the environment or do some other public good. Does not necessarily mean that they do. So after, one of the funny things in Lucas was Justice Scalia's opinion. He said, he wrote a comment. He was always good at these these little acidic comments that he would throw in. He said that this test, this total takings test, is going to basically create a stupid attorney test, where only the stupidest of municipal attorneys will fall into this trap because it's so easy to adjust regulations back so that you don't take all property. I was challenged by a national expert on property rights to show one example of a Lucas taking after that decision, of a total taking after the Lucas decision, especially with the warning of the stupid municipal attorney. Nobody wants to follow in that shadow. So I proved him wrong. It can happen, and it happened here. Up in Nooksack, right up at the Canadian border. Imagine a buffer prohibiting all development and use of property just because of its location adjacent to a stream. In Dunlap, the city of Nooksack, the Dunlaps owned, there's a little red square there, that's a terrible picture, but it was as good as I could get. It's a quarter-acre lot zoned for residential use. Because the Nooksack River does a little hook through their property, it was completely encompassed within, at that time, these were 50-foot buffers. Now we're looking at, 200, 300. We've got groups out there arguing for like 700-800-foot buffers. But the buffers made development of a house completely impossible without a variance. Dunlaps took a picture of their property. The city would not grant a variance because there was a total of just less than 480 square feet of developable land on the property after you applied the buffers. That's what that triangle is. It's triangular in shape. And so they said, we have not deprived you of all of your rights in your property because you could build a house there so long as you build it on stilts. You'd have to park your car under the house. You can have no yard, garden, or fence. Anyway, so we took that to the State Court of Appeals and won. We got a decision from the Court of Appeals applying Lucas, saying that although the state has a legitimate interest in protecting wetlands, its application of those buffers resulted in a total and devastating impact on the lots. The only use allowed was vacant land to provide buffers for the state, for the government, constituted a total taking, and the city was required to pay just compensation. You'd think that would stop them from imposing these buffers, but it doesn't. The buffers are imposed in the form of a permit condition, and this is one area that I litigate very frequently. It's called the unconstitutional conditions doctrine or the unconstitutional exactions doctrine. Or you've heard of the nexus and proportionality tests. We've got a lot of big words in this area. Basically what it says is that if you're going to condition a government benefit, you can't force somebody to waive a constitutional right. This doctrine is a very old judicial doctrine, and it has been used in many different areas of the law, including things like loyalty oaths, requiring people to take loyalty oaths or forswear communism, or a whole bunch of different things in order to get welfare or housing assistance. In the arena of property rights, what it says is that the government cannot condition a land use permit upon a dedication, a requirement that you dedicate a property interest to the government. Because what that does really is it says, give me your land. It's graft. They're forcing you to pay them for a permit that you're otherwise entitled to. That doctrine arose from two cases. The first one is one of PLF's first cases to the U.S. Supreme Court, Nolan v. California Coastal Council. The Nolans bought on the California coast this little dilapidated bungalow. The funniest thing was in the purchase, the government required them to tear it down and replace it as part of the purchase requirement because it was in such bad shape and because it was an eyesore in a community of nice homes. 500 square feet on the beachfront. So Nolan's applied for a permit. Well, the California Coastal Commission comes back and says, sure, you can rebuild your land, but we want that. You can't really see the red, but the red box above is Nolan's home. That was the home that they reconstructed. Down below that red line, they wanted the Nolans to dedicate, who owned all of the beach down to the water, they wanted them to dedicate that portion of property along the beach. The purpose was the state of California had adopted a law saying, we want to connect these two parks that were north and south of this line of homes to create one massive park. So whenever somebody applies for a permit in this neighborhood, require them to give you their beach. Well, Pacific Legal Foundation took that to the U.S. Supreme Court and argued and won a decision that established the essential nexus rule. That test asks whether there is a sufficient connection between the condition and the impact that a new development will have on the public. In other words, if you're going to, say, pave your property on a slope and redirect the water down in a manner that's going to harm or throw runoff onto a stream or flood a road, you can be required to mitigate for that because you're causing harm to the public or to another person or the environment. But if you aren't, and here, how was his building impacting the public's need to connect these two parks? It wasn't. There was absolutely no connection. If there's no connection, then you can't have it. Then it's an unlawful demand. PLF was on the team. We filed an amicus brief a decade later in Dolan v. City of Tigard, trying to refine that because that's sort of a mushy test if you think about it. Is it sufficiently related so that we can argue that what we want is related to what you have? Well, in Dolan v. City of Tigard, the widow Dolan submitted an application to expand a hardware store and pave the driveway. The City of Tigard was operating under something that was much like the Growth Management Act. It had a local master plan that said that anytime you get one of these applications, we want one dedication of property for a bicycle path and we want stream buffers. Dolan appealed and took the case to the U.S. Supreme Court, and the U.S. Supreme Court announced the second part of the unconstitutional conditions test. This is the second part, is rough proportionality. So not only does the demand on a permit have to be related to some externality, some external impact of your land use, but it also has to be related in size. If you're doing that, if you're redirecting water onto the street, you can't ask us to rebuild the entire street. You can't ask us to rebuild the street uphill because there's no impact there. Just limit it to the impacts that you are going to have. Generalized connections, and this is really important in the area of critical area buffers, because as anyone here who has been involved in this knows that this science is just filled with generalities. The initial wave of shoreline buffers came from science developed for Chesapeake Bay that has a completely different geography. The Supreme Court in Dolan said that rough proportionality requires some sort of individualized determination of both the quality and quantity of the harm coming from your property for a dedication to be lawful, because generalized connections are just too lax to protect the owner's right to just compensation. One more wrinkle in the unconstitutional conditions doctrine. This was a case that I was on the team of. I second chaired this to the U.S. Supreme Court, Koontz v. St. John's River Water Management District. In this case, Koontz owned a large parcel, about almost 20 acres of land in Orlando. It's right at the interchange of these two major highways. It was bisected. I don't know how well you can see, but it was bisected by a power line easement, and it was mowed off. There are wetlands down at the bottom. The top end is dry. It was a truck pull-off. Anyway, he applied to develop that lot. This will show you a little closer what I was talking about. He applied to develop the northern portion of the lot, north of the power line easement. The water district, which is one of the preliminary in Florida, they have multiple layers of permits that they have to go through in order to develop property if it's been declared a wetland or if it's close to a river or marsh, which is pretty much Florida. Anyway, he was told that he could only develop that property if he was willing to pay for them to restore these other properties that were miles away. Either that or dedicate so much of his land. He dedicated the bottom completely and just asked for permission to do the top, I believe, 3 acres. They wanted even more. They wanted to reduce it down to 1 acre, which would not pencil out, or for him to pay hundreds of thousands of dollars into a program that had no relation to his permit. So he objected. We took the case to the U.S. Supreme Court, and the U.S. Supreme Court held not only 2 important things for property owners. One of them is denial of a permit because you object to an unconstitutional condition violates the Constitution. So you are entitled to have your permit issued without the offending condition. And 2, demands for money, like demands for property, for real property, are unconstitutional conditions because money is a chattel and is protected by the Fifth Amendment just as much as real property. Okay, so the current issues that PLF is working on in the U.S. Supreme Court, sadly, just earlier this week, that top issue I have listed died at the U.S. Supreme Court. We had another petition at the U.S. Supreme Court dealing with Washington's critical area buffer programs that arose out of San Juan County. That one got turned down, but it's not going to stop us. I have another one in the hopper that I was just looking at today. The U.S. Supreme Court has indicated that it wants to address these issues. It just needs the right case. And the Capo decision was one of the first ones that we took up to the U.S. Supreme Court, where they ordered additional briefing because they were looking closely at the case. Later this term, PLF is going to be arguing what's called the relevant parcel issue. Actually, I'm getting out of order there. Let me just talk briefly about buffers, because this is the most important issue, I believe, to Capo and Washington residents. We hear that buffers don't take property. We hear that they're just regulations or they're just a restriction. That is wrong. The ability to take buffers, the government never had that ability until legislature acted and deemed conservation areas or buffers an interest in real property that can be purchased and sold. When the government is imposing one of these on you, it is stealing a real property interest. RCW 6404130 says, a development right, easement, covenant, restriction, or other right, or any interest less than a fee simple to protect, preserve, maintain, improve, restore, limit the future use of, or conserve for open space purposes, constitutes and is classified as real property. It's not a restriction, it's theft. The Board of Tax Appeals has recognized that buffers are real property, in this case that I listed here, requiring environmental groups that hold interest in conservation easements to pay taxes on them. We have a long line of cases in Washington that recognize that critical area buffers must satisfy the Nolan and Dolan requirements. Starting with the Heel decision out of Seattle, that was the steep slopes decision that John Groen, who's now at PLF, litigated during his first tour with PLF. The King County decision that I litigated. The Capo decision, although we wound up losing that case, we won a heck of a lot. In the first go-round, this was the first challenge to the shoreline buffers in Kitsap County. The first go-round, we got them eliminated. We won the case. But then legislature stepped in and reversed the court and adopted a new law. They changed the game board to allow Kitsap County to do stuff that it had never been allowed to do before. Then when they came back with this newfound authority to regulate shorelines, the Court of Appeals held that critical area buffers must satisfy Nolan and Dolan, which is a very important decision because there is a big split of authority outside of Washington as to whether buffers are the type of demands that requires that sort of protection. But after that's sort of the high watermark in the buffer litigation in Washington. Court changed. I don't know if y'all recall when the Supreme Court turned over. Most of the courts of appeals have turned over, and since then we've gotten a couple of at least one real lousy decision. That was the one that I tried to get to the U.S. Supreme Court, originating in San Juan. In that case, a judge from Division I said that Nolan and Dolan does not provide constitutional protection if the legislature demands your property, only if an administrator demands your property. Wow. Now, I'm gonna ask y'all, you remember that slide with the Fifth Amendment in the Washington State Constitution? Do any of you remember that being limited to one branch of the government?
No.
No. That is a horrid decision. That is one of the issues that we are trying to get to the U.S. Supreme Court. And I recently we've been getting that case denied for like 20 years, but we got just a written decision on the denial out of a case I was handling out of California, where Justice Thomas said that this is of the most importance. This has to be resolved. I see absolutely no constitutional basis for drawing a distinction between a legislative act and another branch of the government. So that will go up, and we won't stop trying to get it up. We're currently fighting buffers also in the Bainbridge Island case, the People for Reasonable Shoreline Management case. That's currently in the Kitsap County Superior Court and should be heating up here in the next few months. But you're going to hear more about this as the year goes on, because John Groen from the Pacific Legal Foundation is going to be arguing the Murphy, Wisconsin case to the U.S. Supreme Court on this issue that's called the relevant parcel question. Now, the relevant parcel issue is just pure shenanigans. Basically what it says, the regulatory taking standard is when the government goes too far. Okay, and then we have Lucas that says when the government takes all value of your property, you must pay. What if you own two properties side by side? You have these two lots. And the government says you can't use this one. Well, the relevant parcel issue, some states have said that so long as you hold any property, they don't care about the metes and bounds of the lot, so long as you hold any property, whether it's adjacent, some states even say in the same city, you haven't been deprived of your property because you still have this one. It's a game of sleight of hand. And we're trying to get that reviewed. That happened in Wisconsin. It was a family that purchased one lot, put a vacation home on it. The family loved it so much that when the lot next door came up for sale later, they purchased that one so their kids could get a vacation home. When they finally saved up enough money to build their cabin, the government said, oh, no, now that's critical. We're not going to let you use it. And then they didn't pay compensation because the family, not even the same family members, but the family itself owned two parcels. We're hoping that the injustice of that is going to resonate with an 8-justice court and that we will get a win. At the same time, I have a case at the Washington Supreme Court that's pretty much the same. It's the same issue, different facts that came out of Sammamish. Keep an eye on our blog, on our communications, because those issues are going to be discussed extensively as we get ready for our next Supreme Court argument.